You're listening to Appeals Court Rejects Parent Rights Argument on Gender Transition Care, a news story written by Toby Raji and Casey Parks, and read by an AI-generated voice. A federal appeals court has upheld a 2021 Arkansas law that bans gender transition care for minors, going beyond a recent Supreme Court ruling on similar statutes in other states to declare that parents do not have unlimited authority to make medical decisions for their children. Lawyers who represent transgender people in other states said in June that the Supreme Court's landmark U.S. v. Scrimeti decision, which found that gender care bans do not violate the Constitution's Equal Protection Clause, left many legal pathways to challenge the law, including the parental rights claim. Tuesday's 8-2 decision by the St. Louis-based U.S. Court of Appeals for the Eighth Circuit could be a setback to those pursuits. Catherine Oakley, Senior Director of Legal Policy for the Human Rights Campaign, called the decision discouraging but not a bombshell. Even though this decision goes further, this is what Scrimeti allowed to happen, Oakley said. Because of Scrimeti, it is going to be a very uphill battle to try to keep any of these bans from going into effect. Scrimeti made it a lot easier for these states to continue to enforce these bans, but that doesn't mean there is no hope in overturning them. It's not impossible that another court would see it a different way. Arkansas in 2021 became the first state in the nation to prohibit transgender people under 18 from receiving puberty blockers, which pause changes in the body due to puberty, as well as hormones such as estrogen and testosterone, which promote the development of female and male characteristics, respectively. While most major medical associations say the treatments are safe and overall beneficial for young people with gender dysphoria, opponents say there is insufficient research on the long-term effects of those treatments. They point to some European countries that have raised concerns about potential harms for young people using puberty blockers and hormones. U.S. experts have disputed the characterization of some of those European findings. Then Gov. Asa Hutchinson, a conservative Republican, vetoed what state lawmakers called the Save Adolescents from Experimentation Act, saying it wrongly allowed the state to override parents and healthcare experts. But the Republicans who control the legislature overrode his veto. A group of young trans people and their parents then challenged the law, which has been on hold for 4 years as both district and federal appeals courts heard challenges to it. Tuesday's ruling was en banc, meaning the full panel of 11 appeals court judges heard the case, rather than the usual 3-judge panel. One judge, whose son is a legislator, recused himself. The case has been on hold so long, the named young plaintiff in the case is now an adult. But it took on new life this summer after the Supreme Court upheld Tennessee's similar ban on gender transition care for minors. In the High Court's majority opinion, Chief Justice John G. Roberts Jr. wrote that Tennessee's ban does not discriminate on the basis of sex, and that courts must give elected officials wide latitude to pass legislation when there is scientific and policy debate about the safety of such medical treatments. Arkansas Attorney General Tim Griffin, Republican, praised the Eighth Circuit's decision, which cited the Supreme Court's ruling in Scrimeti repeatedly. I applaud the court's decision, recognizing that Arkansas has a compelling interest in protecting the physical and psychological health of children, and am pleased that children in Arkansas will be protected from risky, experimental procedures with lifelong consequences, Griffin said in a statement. The American Civil Liberties Union, which brought the original challenge to the 2021 law, alongside a doctor who provided gender-affirming care in the state and for transgender youths and their families, slammed the ruling. This is a tragically unjust result for transgender Arkansans, their doctors, and their families. Holly Dixon, executive director of the ACLU of Arkansas, said in a statement Tuesday, "The state had every opportunity and failed at every turn to prove that this law helps children. In fact, this is a dangerous law that harms children. The law has already had a profound impact on families across Arkansas who all deserve a fundamental right to do what is best for their children." Griffin and the state's medical board filed the appeal with the Eighth Circuit in July 2023, after U.S. District Judge James Moody of the Eastern District of Arkansas blocked them from enforcing the state's ban on medical treatment for transitioning young people. In addition to Arkansas, the Eighth Circuit covers Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. Moody had said the ban violated the rights of transgender people and endangered their health. Rather than protecting children or safeguarding medical ethics, the evidence showed that the prohibited medical care improves the mental health and well-being of patients, and that by prohibiting it, the state undermined the interests it claims to be advancing. In a dissent to the Eighth Circuit's ruling, Judge Jane Kelly, the sole Democratic appointee on the appeals court, wrote that the case should have been returned to the district court, which held an 8-day trial to review scientific evidence and heard from medical experts. Judge James Loken, a George H.W. Bush appointee, joined Kelly's dissent. Unlike Scrimetti, which took the state's justifications for its act at face value, this case involves factual findings from a lengthy trial, Kelly wrote. And those findings, none of which the state disputes on appeal, reveal a startling lack of evidence connecting Arkansas's ban on gender-affirming care with its purported goal of protecting children. In the majority opinion, Judge Dwayne Benton, a George W. Bush appointee, applied Roberts' reasoning in Scrimetti. The minors argue that the act classifies based on sex in violation of the Equal Protection Clause. They argue that a minor's sex determines whether he or she can receive certain medical treatments, Benton wrote. To the contrary, as the Supreme Court explained about a similar Tennessee law, the act classifies based only on age and medical procedure. The minors alternatively assert that the act discriminates based on transgender status, the opinion states. To the contrary, the act does not classify based on transgender status. Like the Tennessee law upheld by the Supreme Court, the act effectively divides minors into two groups. In one group are minors seeking drugs or surgeries for the purposes that the act prohibits. In the other group are minors seeking drugs or surgeries for purposes the act does not prohibit.